Tuesday morning, 9:17 a.m. Coffee still hot in my hand. Tires screech. Boom. A cherry red Jeep slams through my brick retaining wall at 34 miles per hour. Bricks explode across my driveway. Soil cascades down the slope, swallowing my garden whole. 3 weekends of work, gone in 3 seconds. The kid steps out. Not a scratch. Flip-flops. Looks around like he's annoyed. Then his mother arrives. Pearl earrings, blazer, heels clicking across my destroyed driveway, and points her finger straight at my face.
That wall shouldn't be there. My son could have been killed. I'm calling my lawyer.
No apology, just a threat. That was Dolores Hartwell, HOA president, the woman who'd fined me $800 for my mailbox color and Christmas lights. 3 weeks later, they sued me for $45,000, claiming her son had PTSD. She smirked at every single hearing, right up until she didn't have a house anymore.
Dealt with an HOA, Karen?
What would you do? Where are you watching from tonight? Let me take you back about 3 years before that Jeep became a wrecking ball. I'm Garrett Winslow, 44 years old, electrician by trade, property owner by 15 years of stubborn saving. I bought my house on Millbrook Lane in Cedarbrook Estates, a mid-sized planned community outside of Asheville, North Carolina, when the neighborhood was still half built and the HOA was just a 2-page sheet of basic rules. No neon mailboxes, keep your grass trimmed, don't park boats on the street, normal stuff, reasonable stuff. My house sits on a corner lot with a sloped yard, which meant when I moved in, I had to build a proper retaining wall along the east side, cinder block, mortared tight, topped with a wooden cap rail I sealed myself. Took me 4 weekends and about $2,000 in materials. That wall holds back roughly 40 tons of hillside. It's not decorative, it's structural. Without it, my driveway and half my garage would eventually slide into the storm drain. My neighbor Theo, a retired civil engineer, helped me level it. We did it right. The wall also happened to sit about 6 feet inside my property line. Now, Dolores Hartwell. She moved into Cedarbrook Estates 2 years after me. Big colonial on the cul-de-sac, 3-car garage. A lawn service that came every Thursday. She volunteered for the HOA board almost immediately, and within 18 months, she'd maneuvered herself into the president's seat after the previous president, a quiet, retired schoolteacher named Margaret, stepped down after Dolores made her life miserable over a wind chime. Yes, a wind chime. Dolores was somewhere in her mid-50s, sharp-dressed, the kind of woman who sends certified letters about dandelions. She had a way of smiling while she was twisting the knife that I can only describe as deeply impressive in a reptilian sort of way. She held HOA board meetings at her house instead of the community center, which meant only people she liked actually showed up. She issued fines the way some people issue opinions, constantly, confidently, and often without basis. Her first unfair act against me came about 8 months after she took the president chair. I'd added a small workshop lean-to on the back of my garage. Nothing fancy, a corrugated metal roof, pressure-treated posts, a concrete pad. It was behind my fence line, not visible from the street, and I'd pulled the county permit before breaking ground. By the book. Completely. Dolores sent me a notice anyway. Unapproved structure. $150 fine. Removal required within 30 days. I wrote back with a copy of my county permit and a polite note explaining that the HOA's own CC and R.S. That's the covenants, conditions, and restrictions, the governing document every HOA runs on, specifically exempted structures not visible from the street and under 200 square feet. My lean-to was 180. I measured it 3 times. She fined me again, $200 this time. Failure to comply with board directive. I appealed. The appeal board, which consisted of Dolores and 2 of her friends from her Tuesday morning book club, denied it in 11 minutes. So I paid a real estate attorney $300 for a 1-hour consult, sent Dolores a demand letter on actual letterhead, and watched her rescind the fine inside 48 hours without a single word of acknowledgement. The smell of victory there was faint, just a whiff of printer ink and stale conference room air. But I noted something important. Dolores backed down when faced with a credible legal threat. She was a bully who'd built her kingdom on people not fighting back. I filed that away. The next 2 years were a low-grade Cold War. She'd cite me for something. I'd document everything and respond in writing. She'd back off. My neighbor Theo called it bureaucratic judo. That's exactly what it was. The problem with Cold Wars, though, is that they can always go hot. And hot came on a Wednesday morning in early March, when Dolores' son Preston backed her Jeep out of their driveway at what the skid marks later measured as approximately 34 miles per hour, in a residential zone, and drove it straight into my retaining wall. The sound was something between a gunshot and a thunderclap. I was in my kitchen, back to the window, when the whole house seemed to flinch. My coffee mug skittered sideways on the counter. Outside, through the window above the sink, I could see a cloud of pale mortar dust drifting across the driveway like someone had dropped a bag of flour from the sky. I got outside in about 15 seconds. The Jeep had punched through roughly 6 feet of wall. Cinder blocks were everywhere. Some had rolled 20 feet into my driveway. One had taken out a section of copper downspout on the corner of my garage. The wall's wooden cap rail was snapped in half, ends jagged and pale where the wood had split fresh. The hillside soil behind the wall was already starting to slump forward, slow and dark brown and inevitable, like it had been waiting years for exactly this moment. Preston Hartwell was standing in the Jeep's open door, flip-flops, basketball shorts, college hoodie. He looked about 22. He had that particular expression young men get when they know they've done something catastrophically stupid and are trying to calculate whether there's any version of reality where it's not their fault. He was already on his phone. I walked over. "You okay?" First thing out of my mouth, genuinely. Kid could have been hurt. "Fine," he said, not looking at me. Then, into the phone. "Mom, yeah, Millbrook Lane, just come here." I took photos. Every angle, every block. The skid marks on the road, long black arcs that told a clear story about speed. The Jeep's front end, the soil slumping through the gap in the wall. I took a video walking the full length of the damage. I did all of this before Dolores' BMW turned onto Millbrook Lane, because I knew, the moment she arrived, the narrative was going to go somewhere strange. She got there in 4 minutes, heels on asphalt, that sharp clack-clack sound, pearl earrings, a blazer. At 9:15 on a Wednesday morning, the woman dressed for disasters. "Is Preston all right?" she asked me, not looking at her wall. "He seems fine," I said. "Your Jeep disagrees." She looked at the wall then, looked at the Jeep, looked at me. And then she did the thing I should have anticipated but didn't quite. She tilted her head, smiled that smile, and said, "Garrett, I hope you're not planning to make this into some kind of situation. I want you to sit with that for a second." Her son just drove a vehicle through my structural retaining wall at 34 miles per hour, and she was preemptively asking me not to make it a situation. "Dolores," I said, "it already is a situation. There are 40 tons of hillside held back by that wall, and your son just removed 6 feet of it." She called her insurance company right there. I called mine. I also called Asheville City Code Enforcement and filed a report for structural hazard, which meant the city had to come out and assess whether my property was now a safety risk. It was. They red flagged it within 2 days, which created an official record establishing that the wall was necessary infrastructure, not decoration. Here's the first legal financial trick, and write this one down. When someone damages structural property, file with your city's code enforcement immediately. Their written assessment becomes evidence that the court trusts more than your contractor's opinion. Dolores' insurance adjuster came out 4 days later, assessed the damage at $14,200 to rebuild the wall properly, plus $1,800 for the drainage repair. Total, $16,000. I had 2 independent contractors quote the job. Both came in higher. I picked the more thorough bid at $17,400, which my own insurance company approved after reviewing the code enforcement report. Dolores' insurance paid. Case closed, I thought. I thought wrong. 3 weeks after the wall repair was complete, new mortar still faintly white against the weathered block, smelling like wet concrete and fresh wood sealer, I got a letter. Not from Dolores' insurance, from an attorney. Preston Hartwell was suing me. The claim: my retaining wall was built in violation of county setback ordinances and constituted a road hazard. His attorney argued the wall's placement was responsible for the accident. Preston was seeking $45,000 for emotional distress, vehicle damage, and personal injury. His injuries, as listed in the complaint, consisted of a bruised knee and what his doctor's note described, without apparent irony, as general anxiety following a stressful event. I read that letter 3 times. Then I laughed for about 2 minutes straight. Then I called my attorney. The game, as they say, was on. My attorney is a woman named Beverly Okafor, late 40s, sharp as surgical steel, the kind of lawyer who reads HOA governing documents for fun on weekends and finds actual errors. I'd used her twice before for HOA disputes. She charged $275 an hour and was worth every penny. I sat across from her in her office, wood-paneled, smelling of old books and a faint trace of the coffee she drank constantly, and slid the lawsuit across her desk. She read it, didn't say anything for a while. Then she looked up. "His knee," she said. "His knee," I confirmed. "The wall was 6 feet inside your property line." "Correct." "County permit on file, pulled before I broke ground." She leaned back. "Garrett, this is a nuisance suit. They're not expecting to win. They're expecting you to settle, maybe $8,000–$10,000, because fighting it costs more than that. This is the second trick worth knowing. A nuisance suit is designed to make the cost of defending yourself exceed the cost of settling, which is why documenting everything from day one is the only real defense. I told Beverly I wasn't settling. I also told her what I suspected, that Dolores was likely involved in crafting this strategy. The suit had her fingerprints all over it. Preston didn't strike me as the kind of guy who spontaneously retained a personal injury attorney. Dolores, however, was exactly the kind of person who knew one. Beverly filed our response, a motion to dismiss, backed by my county permit, the property survey establishing the wall's location, the code enforcement hazard report, which had now officially cleared the wall as compliant, and a reconstruction analysis from a structural engineer Beverly brought in, which concluded that the wall's position presented no road hazard, and that the accident was caused entirely by the driver's speed. While all of this moved through the courts, Dolores escalated on the HOA front. She was, apparently, not capable of fighting one battle at a time. She called a special HOA board meeting and issued a community-wide notice that my property was under investigation for code violations that may affect property values. No specifics, just that. A vague poisoning of the well, designed to make my neighbors look at me sideways. She also sent a letter to the county tax assessor, suggesting my workshop lean-to was an unpermitted structure worth reassessing for tax purposes. It wasn't unpermitted. This went nowhere. But it cost me 2 hours of phone calls to document that it went nowhere. She put a lien notice on my account for unpaid HOA fines that had been rescinded 18 months earlier, which she was apparently trying to quietly reinstate in the records. Here's where being a documentation obsessive pays off. I had every letter, every rescission notice, every email. I had a folder, an actual physical folder, 2 inches thick with tabs, labeled Dolores, that went back almost 3 years. I sent Beverly the folder. Beverly's paralegal spent 4 hours going through it and came back with something interesting. 3 of the fines Dolores had reinstated in the HOA ledger had never been properly voted on by the full board. Under North Carolina HOA law, fines above $100 require a board vote with quorum, documented in official minutes. These fines had been issued by Dolores alone, recorded only in a ledger she controlled, and never appeared in any meeting minutes. That wasn't just improper. That was potentially fraudulent misuse of HOA financial records. Beverly sent the HOA board, all 5 members, not just Dolores, a formal letter outlining this finding and requesting a full financial audit of HOA accounts for the past 3 years. Dolores responded by calling me directly. First time she'd called me in 2 years. Her voice was controlled, professionally pleasant, with just the thinnest wire of threat running through it like rebar in concrete. "Garrett, I think this is getting out of hand. I'm sure we can resolve this without involving the whole board." "Dolores," I said, "I think involving the whole board is exactly the right call." She hung up. 2 days later, she withdrew the reinstated fines. But here's the thing about people like Dolores. They don't retreat. They regroup. And while I was focused on the lawsuit and the fines, she was quietly doing something I wouldn't discover for another 6 weeks. Something that, when I found out, made the hair on my arms stand up and made Beverly go very, very quiet on the phone. It was my neighbor Theo who caught it first. Theo Drummond, retired civil engineer, 68 years old, spent 30 years designing municipal drainage systems for the state. He walks the neighborhood every morning at 7 sharp. Same route, same pace, same beat-up Carhartt jacket that smells like cedar and motor oil. He notices things. It's a professional deformation, he says. Once you've spent 3 decades thinking about where water goes, you can't stop looking at slopes and gradients. He knocked on my door on a Saturday morning in April, coffee thermos in hand, and said, without preamble, "Someone pulled your survey stakes." I went out with him. Sure enough, the small, orange flag stakes that mark my eastern property line, placed by a licensed surveyor 3 years earlier when I built the wall, were gone. All 3 of them. The holes where they'd been were fresh, recently disturbed, the soil around them dark and loose compared to the packed earth a few inches away. This mattered. Here's why. Preston's lawsuit was arguing, in part, that my wall was built too close to the road, that it violated setback ordinances. If the survey stakes were gone, establishing the wall's exact position relative to my property line required resurveying. Resurveying takes time. Time delays the lawsuit's dismissal motion. Delays are expensive. And if the resurvey came back with any ambiguity, even a few inches of measurement variance, their attorney could argue the wall's position was uncertain. Someone had pulled those stakes to create delay and doubt. I filed a police report. Removal of survey monuments is a crime in North Carolina, a Class 1 felony under NCGS 3968, actually. The officer who came out was professionally skeptical, the way officers are when a crime scene consists of 3 holes in the ground. But he took the report. That report existed. I immediately hired the same surveyor to restake the property. She came out within the week, re-established all 3 pins, and this time I photographed every stake with GPS coordinates from my phone, then had her prepare a certified survey document with exact measurements and a sworn affidavit of placement. Third trick to know: a certified survey with a surveyor's sworn affidavit carries legal weight that informal stakes don't. It's court-admissible proof of property line placement. Now I had something better than the original stakes. I had a document. Meanwhile, I was also piecing together something larger. Beverly's audit request had shaken loose more than reinstated fines. 2 of the other HOA board members, Randolph Cass and Patricia Engel, both of whom had joined the board before Dolores but been gradually sidelined, reached out to me separately. They were quiet about it, guarded even, but they told me they'd been concerned for over a year about financial irregularities they couldn't fully document. The HOA managed a reserve fund, money collected from dues to cover major community expenses, roof repairs on common areas, repaving the entrance road, that kind of thing. The reserve fund was supposed to hold around $180,000, based on the association's own budget documents. When Randolph had asked to see a current accounting 2 months earlier, Dolores had told him the fund was under review and provided no documentation. That was odd. I asked Beverly what it would take to compel a full financial disclosure. She said, "Any 2 board members can formally request an audit under North Carolina HOA statutes. If Randolph and Patricia submit that request in writing, Dolores has to comply, or the board can vote to remove her as president." I spent a Saturday afternoon at Randolph's kitchen table, his wife bringing out sweet tea that tasted like summer and sugar cane, going through what we knew and what we needed. Randolph was methodical, careful, a former bank branch manager. He understood financial records. "She's been running this HOA like a personal fiefdom," he said. "But fiefdoms have ledgers, and ledgers have lies." He and Patricia submitted the written audit request the following Monday. Dolores called an emergency board meeting for that Thursday. At the meeting, which I attended as a homeowner, which is my right under the CC&Rs, she announced that the audit request was procedurally improper and subject to review. She tabled it. She controlled the agenda, the chair, and the room temperature, all 3 of which she kept uncomfortably high. But the request was now in writing, officially submitted, officially tabled without resolution. And that meant, under North Carolina statute, that the homeowners themselves could escalate to the county and, if necessary, to the courts. We were 3 months into this fight. The lawsuit was still grinding through motions. The audit was blocked. The survey stakes had been pulled and replaced. My wall stood, repaired and solid, the new mortar now weathering to match the old. and none of us yet knew what was actually hiding in that reserve fund. The answer came from a plumber, not metaphorically. An actual plumber, a guy named Dusty, who did the HOA's common area maintenance work and had been sending invoices to the association for 3 years. He called Randolph in early May because his last 4 invoices, totaling $11,200, had gone unpaid. He'd been patient. He was done being patient. Randolph got Dusty's invoices and compared them against the HOA financial records Dolores had shared with the board, the sanitized summary version she distributed at meetings. The invoices weren't in the records. The payments, supposedly made, didn't appear in any bank documentation Dusty had received. So where had the money gone? Beverly subpoenaed the HOA's actual bank account records as part of our escalating legal action. What came back was a set of documents that Beverly described on the phone as a slow-motion train wreck. The HOA reserve fund didn't hold $180,000. It held $23,000. Over a period of roughly 2 years, approximately $157,000 had been transferred out, not in large lump sums that would trigger obvious flags, but in steady withdrawals of $3,000 to $8,000, most of them authorized by the account's sole signatory, Dolores Hartwell. The transfers went to what was listed as management and administrative fees for a company called Cedarbrook Property Services LLC, which was not a real company, which was, when Beverly ran the registration, a single-member LLC registered in North Carolina 18 months ago. To Dolores Hartwell, she had been paying herself $157,000 in fake management fees out of the community's reserve fund. There's a specific kind of silence that happens on a phone call when someone has just told you something that makes everything suddenly, starkly clear, where all the small pieces that didn't fit now lock together with an almost audible click. That's what happened when Beverly told me this. She's not just petty, I said. No, Beverly said. She's a thief. This wasn't an HOA dispute anymore. This wasn't a nuisance lawsuit or pulled survey stakes. This was wire fraud, breach of fiduciary duty, and potentially criminal misappropriation of funds, in the neighborhood of $157,000, which in North Carolina is a Class C felony carrying up to 15 years in prison. The lawsuit Preston had filed against me, the $45,000 suit about a bruised knee and anxiety, suddenly looked very different in context. It wasn't just a nuisance tactic. It was almost certainly a pressure maneuver designed to keep me tied up, financially stressed, and less likely to dig into HOA finances. The wall wasn't the point. I was a problem, and problems need to be managed. Beverly immediately notified the court overseeing Preston's lawsuit about the discovered financial irregularities and our intent to file a counterclaim. She also contacted the North Carolina Attorney General's Consumer Protection Division, which handles HOA fraud complaints, and filed a formal report with documentation. I called Randolph, then Patricia, then Theo, who listened to everything I said and was quiet for a long moment, and then said, "Well, I always said water finds the cracks. We had what we needed. Now we needed to use it correctly. Blow this the wrong way, go public too soon, tip her off, give her time to move money or destroy records, and she walks. Do it right, and she doesn't just lose the HOA presidency, she loses the house." The next 3 weeks were the quietest, most productive weeks of the entire fight. Beverly moved on 3 fronts simultaneously, and watching her work was like watching someone defuse a very complicated bomb, while also building a better bomb of their own. Front 1 was the lawsuit. Preston's case was already wobbling. The dismissal motion had strong legs. But now, Beverly amended our response to include a counterclaim for malicious prosecution. In North Carolina, if you can show that a lawsuit was filed without probable cause and with malicious intent, the defendant can recover attorney's fees and damages from the plaintiff. The connection between Dolores's financial fraud and the timing of Preston's lawsuit, filed 3 weeks after our insurance dispute, just as the HOA audit questions began surfacing, formed what Beverly called a coherent pattern of bad faith legal action. She laid it out methodically. The lawsuit wasn't about Preston's knee. It was designed to drain my resources and attention at the exact moment Dolores was most vulnerable to scrutiny. That's not litigation. That's weaponization. The practical takeaway: malicious prosecution counterclaims are rare but powerful. They're available when a lawsuit is provably filed to harass, rather than to seek legitimate redress, and they can result in the harassing party paying your legal costs. Front 2 was the financial fraud investigation. Beverly worked with a forensic accountant, a woman named Dr. Sylvia Grant, who specialized in nonprofit and HOA fund mismanagement and had testified in court 17 times, to build a complete paper trail from the HOA's actual bank statements to Cedarbrook Property Services LLC. Dr. Grant found not just the $157,000 in fake management fees, but an additional $14,800 in what appeared to be personal expense reimbursements, including what was labeled community enhancement materials, but corresponded in timing and amount to Dolores's kitchen renovation, which several neighbors had watched happen the previous spring, complete with a Viking range and custom cabinetry. The kitchen renovation that the HOA apparently paid for. Randolph, when told this, put his head in his hands and made a sound that was half laugh, half despair. "She renovated her kitchen with our roof fund," he said. "Viking range and all," I confirmed. Dr. Grant's report went to the Attorney General's office and simultaneously to the county sheriff, who has jurisdiction over criminal fraud cases. The AG's office referred it to a special crimes unit that handled HOA and nonprofit financial crimes. An investigator was assigned. A quiet, careful investigation began. We were explicitly told, do not warn her, do not tip her off, do not let her know what's coming. Front 3 was the structural ground game, making sure that when this broke publicly, the community understood what had happened and what it meant for their finances. Theo, Randolph, and Patricia quietly contacted every homeowner in Cedarbrook Estates who'd ever had a problem with Dolores. People who'd been fined unfairly, people who'd been ignored in board meetings, people who'd asked about the reserve fund and been brushed off. They didn't tell anyone the full picture. They just asked, if there were a special board meeting to address financial irregularities, would you come? Every single person said yes. Meanwhile, I did something that might seem small but turned out to matter enormously. I contacted the local Asheville Citizen-Times and spoke off the record with a reporter who covered local government and community issues. I didn't give her everything. We weren't ready for that. I gave her enough to make her interested. HOA president, possible financial fraud, a lawsuit against a neighbor involving her own son. She started making her own inquiries. She filed public records requests on her own. The machine was running. All of us moving in our separate lanes, quiet and deliberate, while Dolores continued operating as if she'd successfully neutralized me and everything was fine. She had no idea what was coming. The last thing I did during this period was make sure my wall was absolutely, photographically, permanently documented as code compliant. I hired an independent licensed structural engineer who'd never worked for me before to inspect the rebuilt wall, certify its placement, construction quality, and compliance with every applicable code. His report was 14 pages. I had it notarized and filed a copy with the county building department. If Preston's lawsuit somehow survived, which it wasn't going to, but just in case, there would be no ambiguity, no measurement dispute, no room for his attorney to manufacture doubt. The new wall was better than the old one. Reinforced footing, drainage aggregate behind the block, steel rebar through every other course. Theo had helped me spec it. It was built to last 50 years, and it would outlast Dolores Hartwell's time in Cedarbrook Estates by a considerable margin. Dolores, to her credit, was not passive. She could sense something shifting, the way a person who has operated through intimidation can always sense, at some cellular level, when the intimidation is no longer working. She couldn't identify the threat precisely, but she knew the temperature had changed. She started with the smear. She sent a letter to all 47 homeowners in Cedarbrook Estates, 4 pages, single-spaced. It detailed, in exhaustive and selectively edited terms, my pattern of adversarial behavior toward HOA governance. It described the original lean-to dispute as my having built an unauthorized structure and refused to cooperate with reasonable board directives until legal threats were made. It described the wall incident as an ongoing insurance dispute stemming from ambiguous property boundaries. It described my attorney's audit request as an attempt to destabilize the association's financial management during a sensitive transition period. 4 pages of that. It also contained a new HOA fine, $500, for harassment of board officers. There is no such violation in the Cedarbrook Estates CC and RS. Beverly looked, twice. The letter backfired in a way Dolores hadn't anticipated. Several homeowners who received it called me directly, not to express concern, but to say, essentially, what's actually going on? Because this letter reads like someone who's scared. Dolores had tried to rally the neighborhood against me, and instead telegraphed her own anxiety. She then escalated to what I can only describe as low-grade sabotage. My mailbox was vandalized, the post leaned, the box itself dented, as if someone had driven close and clipped it. Could have been an accident, probably wasn't. I installed a Ring camera on my mailbox post. The next week, someone came back, at 2:14 a.m.
on a Thursday, and knocked it fully over. The camera caught a vehicle, a BMW 5 Series, dark blue, same color as Dolores's car. License plate partially obscured by something placed over it, a piece of dark material, deliberately applied. I gave the footage to the investigating detective. He didn't say much. He nodded and saved a copy. On the HOA front, Dolores attempted something clever. She called a special board vote to amend the CC and RS to give the board president unilateral authority to authorize expenditures up to $25,000 without board approval. It was timed, I later understood, to retroactively legitimize her management fee payments. If she could establish a precedent of presidential financial authority, she might argue the transfers were within her powers. Randolph and Patricia voted against the amendment. It failed 3-2. Dolores accused them of procedural bad faith in the minutes she wrote, which Randolph immediately contested in a written correction filed the same day. She was trying to build a legal exit. It was closing. The investigation, meanwhile, was moving quietly but not slowly. The forensic accountant had provided a complete financial narrative. The sheriff's fraud investigator had interviewed Dusty, the plumber, two former board members who'd been pushed out before Randolph and Patricia, and the owner of a landscaping company who'd had similar unpaid invoice issues. A pattern was established. The money trail was documented with bank records that Dolores couldn't dispute. The detective told Beverly, carefully, that they were approaching a point of action. Beverly told me, equally carefully, that the court date on Preston's lawsuit was now set for early June, 6 weeks out. Given the counterclaim for malicious prosecution and the motion to dismiss, she expected either a dismissal or a settlement offer before the hearing. "What if they offer to settle?" I asked her. "What do you want?" "I want this on record," I said. "I don't want a confidential settlement where none of this can be discussed. I want whatever happens to be public." Beverly smiled. I could hear it over the phone. "Then we don't accept confidentiality clauses. We let them offer. We counter with terms that keep the record open." There was one more piece in play that I hadn't mentioned to anyone outside of Theo and Randolph. A few weeks earlier, going through old HOA meeting minutes from before Dolores's presidency, I'd found something that made the entire situation even more complicated for her. The original HOA charter, drafted in 2006 when Cedarbrook Estates was built, contained a provision that the developer's attorney had inserted as standard boilerplate. In the event of financial fraud or criminal misappropriation by any board officer, the HOA retained the right to place a lien on the offending officer's property within the community. Dolores owned a home in Cedarbrook Estates. The HOA, her HOA, could potentially lien her house. Let me tell you about the week before everything broke open. Dolores made one final move. It was the most aggressive thing she'd done, and it was also the clearest sign that she knew the ground was disappearing under her feet. She contacted Preston's attorney and authorized a revised settlement offer. They would drop the lawsuit with a mutual confidentiality clause, and Dolores would personally resolve the outstanding HOA fine issues, in exchange for my agreement to withdraw all audit requests and counterclaims. In plain language, she wanted me to sign a document that would bury everything: her fraud, the investigation, the malicious prosecution counterclaim, in exchange for making a lawsuit she never should have filed go away. She was trying to buy silence. Beverly called me when the offer came in. We both stayed quiet for a moment. "That offer," Beverly said finally, "tells us everything we need to know about her state of mind." "We decline," I said, "obviously. But Garrett, there's something else. The investigation is at a point where our declining this offer may accelerate their timeline." The detective had told Beverly, informally, that they had enough for charges. The question was sequence. They wanted to make sure civil proceedings didn't complicate criminal evidence. Our declining the settlement and proceeding to the June court date kept the legal pressure on from our side while the criminal process ran its track. I spent those last days doing something oddly peaceful. I prepped for the board meeting, the special homeowner meeting that Randolph and Patricia had quietly organized, not an official board meeting but a homeowner forum, open to all 47 properties in Cedarbrook Estates, was scheduled for the Saturday before the lawsuit's court date. The timing was partly deliberate and partly just how the calendar fell. Theo helped me prepare a presentation, nothing fancy. A projector, a screen borrowed from the community center, a stack of printed documents for anyone who wanted copies. The financial summary Dr. Grant had prepared, translated from accounting language into plain numbers a homeowner could follow in 3 minutes. The charter provision about HOA liens, the history of the audit request, and its repeated obstruction. We weren't going to ambush Dolores at the meeting. She'd been notified of the forum, along with everyone else. We weren't going to make accusations beyond what the documents showed. We were simply going to let the numbers speak. I also spent a quiet evening rereading the CC and Rs, all 37 pages of them. The thing about Dolores was that she had used these documents as weapons for 3 years, and she knew them well. But she'd read them the way a bully reads rules, looking for leverage, not for constraint. I'd read them looking for every protection available to a homeowner, and I'd found them. The charter lien provision, the board removal procedure, the audit rights, the requirement for documented minutes on all fine approvals. The documents that were supposed to give her power were the same documents that were going to take it away. I also, and this was Beverly's suggestion, filed a formal notice with the County Register of Deeds documenting the pending fraud investigation and its potential lien implications on Dolores's property. This notice didn't place a lien. It just made public record that such action was under consideration. What this meant practically is that Dolores could not sell her house, refinance her mortgage, or obtain any credit secured by the property without this notice appearing in a title search. She was, financially, frozen in place. I learned later, much later, from the detective, that when Dolores discovered this filing, she tried to immediately contact a real estate agent to list the house. The title notice appeared in the pre-listing search. The agent told her the property couldn't be marketed in its current legal status. Dolores had apparently been planning to sell, pocket whatever equity remained, and disappear before the whole thing came down around her. The filing stopped that. One of the last things I did that week was drive past my wall. New mortar, good block, steel rebar running through it clean and straight. The hillside behind it solid and contained. A few tulips had come up in the garden bed I'd replanted after the wreckage, red and yellow, moving in the spring wind. The wall had survived a Jeep going 34 miles per hour. It was going to be fine. I drove home, called Beverly to confirm Saturday's timeline, and went to bed early for the first time in 3 months. The homeowner forum was held on a Saturday morning in early June at the Cedarbrook Estates Community Center, a building that, I noted with some satisfaction, the HOA Reserve Fund was supposed to have repainted last fall and hadn't because the money wasn't there. 41 of 47 homeowners showed up, people I'd barely spoken to in years. Margaret, the retired school teacher who'd been chased off the board by Dolores over a wind chime, sat in the front row in a yellow cardigan and looked like someone who'd been waiting for this moment for a long time. Dolores arrived 7 minutes late, dressed as sharply as always, with Preston beside her and an attorney I didn't recognize. The attorney was young, mid-30s, suit slightly too big, and had the expression of someone who'd been given a very difficult assignment on very short notice. Randolph opened the meeting. Patricia took notes. Theo ran the projector. I presented the financial summary first. Just numbers. Reserve fund balance. Supposed to be $180,000, actually $23,000. Transfer history. $157,000 to Cedarbrook Property Services LLC over 22 months. LLC registration. Single member, registered to Dolores Hartwell. I put her signature from the LLC registration documents on the screen next to her signature from the HOA bank account authorizations. Same signature, same person. I gave everyone a minute with that. The room was very quiet, the kind of quiet that has weight. Dolores stood up. Her attorney put a hand on her arm. She shook it off. "These documents are taken out of context," she said. Her voice was controlled but working hard to stay that way. "The management fees were a legitimate—" "Dolores," Randolph's voice was quiet and final. "The bank records are from your own account. The LLC registration is a public document. There is no context." Dolores's attorney whispered something to her. She sat down. I then walked through the lawsuit. Preston's $45,000 claim, the timing, the connection to the audit requests, the malicious prosecution counterclaim. I showed the court filing confirming the case was scheduled for hearing in 4 days, and the settlement offer they'd made to buy my silence, which I'd declined. I read that offer into the room, out loud, every condition. Margaret, in the front row, made a sound that was not quite a laugh and not quite a gasp. Then the door opened. 2 deputies from the Buncombe County Sheriff's Office, not dramatically. They weren't there to arrest anyone in that room. They were there to serve a notice. A criminal complaint had been filed against Dolores Hartwell for wire fraud and misappropriation of funds. The complaint was a matter of public record as of that morning. The attorney in the 2 big suits stood, gathered his papers, and quietly said something to Dolores that none of us could hear. Whatever it was, she nodded. She stood. She looked at the room. 41 homeowners, some of whom she'd fined, harassed, overridden, or simply ignored for years. And she walked out without a word. Preston followed. He had his hands in his pockets and stared at the floor. Whatever else you could say about the kid, he knew when a room had made its judgment. The deputies left. The door closed. And then, I didn't plan this. Nobody planned this. Somebody started clapping. Margaret in the yellow cardigan. Then the man beside her. Then the couple in the back who Dolores had fined for their vegetable garden being half an inch too tall. Then everyone. Not wild or cruel. Just steady, relieved applause that sounded like rain starting on a dry summer afternoon. I sat down. Theo put his hand on my shoulder. "Good wall," he said. 4 days later, Preston's attorney filed a voluntary dismissal. The lawsuit was dropped without prejudice, which Beverly immediately moved to convert to a dismissal with prejudice, meaning it couldn't be refiled. The judge granted it. Beverly also filed the malicious prosecution counterclaim as a separate action, which resulted, 2 months later, in a default judgment in my favor for $23,400 in legal fees and damages after Preston and Dolores failed to respond to the complaint. The criminal charges against Dolores resulted in a plea agreement, restitution of $171,800 to the HOA, 3 years probation, and a prohibition on ever serving in any fiduciary capacity, which in practical terms meant she could never sit on another board, manage another HOA, or hold any financial trust position. The HOA placed a lien on her property for the restitution amount. She could not sell without satisfying it. She could not refinance. She was stuck. 6 months after the forum, the house went to foreclosure. The thing about a story like this is that the satisfying part isn't really the downfall. Watching someone like Dolores collapse under the weight of her own choices, that's real, and it's earned. And I won't pretend there wasn't a moment when I heard about the foreclosure and felt something that I'd call justice if I was being precise, and deeply satisfying if I was being honest. But the real ending isn't about her. The Cedarbrook Estates HOA held new board elections 6 weeks after the forum. Randolph was elected president by a margin that made the old elections look embarrassing, 38 out of 41 votes cast. Patricia became treasurer. Theo, who had never wanted to be on any board ever, reluctantly agreed to serve as a non-officer community liaison, which mostly meant he walked the neighborhood every morning like he always had. But now people stopped him to talk about drainage and property maintenance with an air of genuine collaboration. The reserve fund restitution, $171,800, paid in a court-supervised, structured arrangement from Dolores's assets, and, ultimately, the foreclosure proceeds, was deposited back into a new, transparently managed HOA account. Every homeowner received a financial statement. Every transaction was documented in board minutes. Randolph hired a professional HOA management company to handle the accounting, with full quarterly audits. The community center got repainted. The entrance road got its repaving. Dusty the plumber got paid, with interest, and signed a new maintenance contract. Here's what I found when it was all over, going through the papers one last time before I finally recycled that 2-inch folder labeled Dolores. The entire fight had cost me $4,200 in direct legal fees above what insurance covered. The counterclaim judgment gave me back $23,400. Net positive, $19,200. I used it to fully fund a college scholarship in Margaret's name, the retired school teacher who'd been driven off the board over a wind chime, who showed up in a yellow cardigan, who started the applause. The Margaret Elaine Hooper Community Scholarship. First award went to a kid from Cedarbrook Estates, 18 years old, heading to study civil engineering. He wanted to design bridges. Theo cried at the announcement dinner. He denies this. Preston, for what it's worth, reached out to me once. A text, brief and slightly awkward, to say he was sorry about the wall. Not about the lawsuit, notably, just the wall. I wrote back, appreciate it. Stay off my street at 34 miles per hour. He didn't respond. That's fine. Some lessons take longer. As for me, the wall still stands. It'll outlast all of us. The tulips came back a second year, red and yellow, same as before. Sometimes I have my coffee outside in the morning and just look at the thing. $2,000 of materials, 4 weekends of work, 1 Jeep through the middle of it, and 3 years of everything else. It held.
You know what nobody tells you about winning is quiet. No big moment, no apologies. All of us just stop showing up to hearings, to board meeting, eventually to the neighborhood entirely. One morning, there was a foreclosure notice stapled to her front door. Same door she used to walk out of to hand deliver violation letters to people like Garrett. $157,000. That's what she stole. Not from a corporation, not from a bank, from the neighbors who live 30 feet away from her. The roof fund, the reserve account, the money everyone paid thinking it was protecting their homes. She spent it on a kitchen renovation. Most people in Garrett's position would have just paid to make it go away. $10,000 to end the headache. Doris was counting on that. She's probably done it before. The people who pay quietly are the reason people like her don't stop. So before you scroll, do you actually know who controls your HOA reserve fund? Do you know what's in your CC&Rs? What people don't until it's too late. Share this if it hits close to home. Subscribe for more and drop your HOA stories below. The less power someone actually has, the harder they fight to keep you from knowing it.